One of the first cases I want to start with is back in about 1988, we sued a doctor for medical malpractice. And back in those days, it was very, very difficult to sue a doctor and succeed because most people held the doctors in very high esteem, and it was very difficult to prove that they were negligent in any way. Anyway, I was fortunate to represent a little boy that sustained brain injury as a result of a botched labor delivery here in Henry County, but the doctor was in Clayton County, so we sued both the doctor and the hospital. Basically what had happened, just in very short and succinct manner, is the doctor, the mother went into labor at the hospital, and they had no anesthesiologist on call, or I should say there at the hospital, so they had to call an anesthesiologist. They could not get anybody closer than in Atlanta, which is about 35 to 45 miles away, and protocol required that they have somebody here within 30 minutes. So the mother went into labor. They weren't able to get, nobody was on call here. They called for the person that is the anesthesiologist up in Atlanta. By the time he got here, the doctor felt it necessary that he had to go in and deliver the child with forceps. And unfortunately, as a result of that, the child sustained brain injury and brain damage. Once that happened, that was the basis of our claim, is the fact that if they had an anesthesiologist on call and within a reasonable distance, this would not have happened. It was completely avoidable if they had followed protocol. What becomes interesting now is the trial of the case. After we get ready to start the trial of the case, the first day we have an expert witness that is up in Michigan, out of state, that we have to bring in to testify. That is our very first witness. So we start the trial. Our very first witness comes in and we put him on direct examination. And so that takes the first day of testimony. Monday, after we finish his testimony, he leaves to go back to Michigan. Okay, now remember at that point, he hadn't been cross-examined by the other party, by the other side, the defendant in these cases. Well, when he returns back to Michigan, he refuses to come back the next day to testify. Obviously, it's a colossal mess at that point. So we notify the judge that he just says, I'm not coming back. He had to go out of town in a day or two after that, and he wasn't going to come back to testify. So we had a couple options. After 2 years or 3 years of preparation, in this case, nobody wanted to start all over, where they could have declared a mistrial and started the case all over. Nobody wanted to do that because time and effort had already put in. The judge was, of course, upset and held the doctor in contempt and said if he ever stepped foot back in Georgia, he was going to put him in jail because of what he had done and what problems he had caused. So anyway, the solution, we did come up with a solution, a very costly solution. What transpired at that point in time, we agreed, the attorneys got together, and we agreed that what we would do is now we're talking about Monday night, we would fly the next morning, Tuesday, up to his office in Michigan. The attorneys for the plaintiffs, the attorneys for the defendant, and a court reporter, we would fly up to Michigan to take his deposition. We do a video, and so therefore they could have their opportunity to cross-examine and the trial could continue. But to great expense and cost to the plaintiff, that's us in this case, we had to pay for everybody's airfare, not only ours, but defense attorneys and a court reporter and the videographer to go to Michigan to take care of all this. Plus we had to get the doctor to cooperate because he was up there seeing patients, so we had to get his cooperations. So you can understand that this was just a fiasco. It was mind-boggling, but in order to keep this case rolling, and we'd already spent tremendous expense, that's what we ended up doing. And fortunately, we were able to go up to Michigan, we were able to take his deposition that day, get all the logistics, get all that completed, and come back and continue our trial. So we finished the trial. The trial was finished, and after the jury was deliberating, the doctor, before the verdict came, the doctor, he left. He left. He didn't stay around for the verdict. This is before the jury made a decision. He leaves and he goes. Of course, it didn't matter as much at that time because the evidence was closed, but it's very unusual for the defendant, especially the doctor, just to leave and not come back. And that's what he did at that point. We didn't know where he went. And there was no reason given, but just another unusual quirk in this particular case. And I just, so you know that I'm just not making this story up, I've got just a few newspaper clippings just to show you that it actually did happen. And a jury awards $3.16 million in a negligence suit. And also the jury award, it was at that time Clayton County's highest verdict in this particular type of case. But the case didn't stop from there. What had transpired after that is, of course, the defendant and the doctor, they ended up filing a lawsuit. Well, a couple things we requested in this particular case. First, we went to court and we requested a cash bond for $3.16 million from the judge to ensure that we didn't know, since the doctor left town and we couldn't locate him, we asked for a cash bond. Fortunately, they had enough insurance, and that was the hospital, had enough insurance to cover the judgment, so the judge denied our request. But what they did, that is the defense and the insurance company, they filed an appeal. Now, they thought they were being smart in a way. They filed the appeal. We anticipated they would do that. But what they didn't anticipate is they thought that maybe my client would accept it somehow, some way, but they would also have to pay interest. Interest on that would have been about $750,000 a year was the interest on that judgment. So I told my client, I said, we've got a good case here. I said, the insurance company's just trying to bully you to accept, because then they started making offers of $1 million and $1.5 million and $2 million. And I advised the client, just sit tight. They're not going to go through this because it's costing them $750,000 a year in interest. So if we, and these normally appeals take 2 or 3 years going through the appeal process, they would have ended up paying another $1.5 million or possibly $2 million, depending upon how long it took for the appeals to work through the system. So I advised the client just to sit tight. I had a feeling, but I also knew that the insurance company was not going to drag this thing out that long, and noting that they were going to have to pay another $1 million plus, $1.5 million, maybe $2 million. So as I suspected, they did file the appeal, and it lasted about 6 months. And after 6 months, they continued. We had negotiations. We're not able to reach an agreement. So after 6 months, they finally paid it off, and they paid the full judgment off. I think we gave them a few dollars off for some of the interest that accrued, but very little. And so fortunately, my client was able to, get his recovery that he needed. The child, unfortunately, had brain damage and needed a life care plan, which that was the reason that the $3.16 million was awarded for the benefit of the minor child. And we were successful in obtaining that results in very difficult times. As I stated, it was very difficult, these medical malpractice cases, to win them. And in this particular case, Clayton County, back then, was a very conservative jury, conservative county, and the juries were very conservative. And so therefore, we felt ecstatic and elated that we were able to make a recovery for the client. But there was a couple of those very touch and go moments that we didn't know what were going to happen at the time because of all these little things that transpired that were sidelights to the case. But I thought that was an interesting case to start with, and one that had these little tidbits in it that you would find hopefully interesting.